Hello, and a very warm welcome to you all for this afternoon's webinar from Thomas Westcott. In a week where the nation has breathed a collective sigh of relief now that the kids have gone back to school, we're actually this afternoon looking at the other sort of age spectrum, and we're looking at later life financial planning. My name is Patrick Tigwell. I'm a general practice partner with the firm based at Exeter and Tiverton. And again, it's my pleasure to be your host for this afternoon's webinar. We're very pleased to welcome a lot of you today. It's a very well attended webinar, so we're very pleased at that. I would say it's of particular interest to me, the issues that my colleague Simon will talk about, as my mother went into a care home last year, and I can always remember that shock of seeing what the actual monthly fees were for the care home. And then, the next step is to do the calculation of how long her savings would last. So it's all sobering stuff. And we were dealing with powers of attorney and all this sort of thing. So I imagine that a lot of these issues will resonate with many of you on the call today. To take us through the issues, and planning opportunities, I'm delighted to welcome my financial planning colleague, Simon Lake. Now, Simon is part of our sister company, Thomas Westcott Financial Planning. He's based in Plymouth, but his colleagues are also based in Exeter and Weston, and between them, they cover the whole of our patch of Devon and Somerset. So very welcome to Simon. I'm also pleased to say, actually, on the attendees, we're due to have Simon's dad on the call. So if you're here, then a very good afternoon to you, Mr. Lake Senior. So we do practice what we preach. Simon's dad's on the call, so that's great. Simon is our only presenter today. Sometimes, we obviously have 2 or 3 speakers. But what he's going to do is his presentation is divided into segments, and we can ask questions, or I will ask him questions after each sort of segment, so as we go along. Talking of which, we have had some questions come in, but if you haven't yet submitted a question, you still can on the Q&A button down there, and then we can get to them hopefully live within the webinar. If we run out of time, or if the question is sort of too detailed, we will answer it after the webinar, and you still can ask a question after the webinar is finished at events@thomaswestcott.co.uk. If you rather your name wasn't read out, I can very much appreciate that. Just put "anon" at the start of your question, and that's fine. And do remember that for practical purposes, we can only answer more general questions, or Simon can. If it's a very detailed question about your personal affairs, we will answer it, but we'll answer it probably after the webinar. I'd like to thank Elisa Freeman for her efforts today. She's, as ever, organised the webinar. She's recording it, and we'll send all our lovely attendees a copy of the YouTube link. And on that email to you, she'll also ask you to put some feedback on the survey, because your feedback is very important, because it enables us to sort of guides our future webinars and the way we conduct them. So without further ado, I will pass over to Simon for his first tranche of his presentation. So Simon, over to you.
Thank you, Patrick. I'm going to open the slides and share my screen. There we are. So an introduction to later life planning. So this is designed really a session for both families and fiduciaries. And what we mean by fiduciaries is that those who make decisions on behalf of others. So that could be an attorney or a deputy, for example. Okay. There we are. So on today's agenda, so I'm going to talk about what is later life financial planning. It might be a new topic for a lot of people. We're going to be talking about attorneys, deputy planning. We're going to be talking about state funding and benefits for people who do require care fee funding. We're going to talk about local authority funding and their rules. We're going to be talking about something called deliberate deprivation, which is quite an interesting topic about what you can do or what you can't do with your money if care fees are on the horizon. And we're going to be talking about how we help our clients with paying for care, some ideas. Then we're going to summarize this with some concluding remarks. And in between then, Patrick and I, we're going to go through some questions as they arise. So about your speaker. I've been at Thomas Westcott since 2017. I'm a chartered financial planner and a fellow of the Personal Finance Society. The Personal Finance Society is the financial services arm of the Chartered Insurers Institute. I've been working in financial services since 2003. I work alongside my accountancy colleagues at Thomas Westcott and other professionals such as those in the legal sector, including a number of law firms around the region. And those typically act as professional attorneys and deputies. My personal qualifications and memberships include the following. I have a law degree, as I said, fellow, chartered, and a number of the certificates that I've taken over the years. Basically, I like sitting and I like passing exams. But my more recent accreditation in the last few years is that I've become an accredited member of the Society of Later Life Advisors, or SOLLA, which is the special accreditation aimed at more vulnerable people and later life financial planning. So before we start, Thomas Westcott Chartered Financial Planners, we're a regulated organisation by the Financial Conduct Authority, just some compliance slides to start with. The important things to be aware of is that any mention of any products or any benefits, obviously they're subject to change each tax year. Any scenarios explored in this presentation may have been based on real events, but they're not to be considered as personal advice or personal recommendations. And the rules covered in this presentation, to the best of our knowledge, are based on the laws from England and Wales, not Northern Ireland or Scotland. So what is later life financial planning? It often centers around care fees and the cost of care for somebody later on in life. Essentially, someone's expenditure may increase significantly if their needs increase, i.e. they need to go into a care home. And it's not a decision anyone takes lightly. It can often happen in an unpredictable fashion, and people need to make quite quick but important decisions under pressure. The challenge of managing finances for elderly relatives or clients, if they're managed by a professional attorney or deputy, or if the family need to get involved, it's often the children or maybe the grandchildren who have to make decisions on behalf of parents or other family members. It's a big responsibility. They may have to navigate the state funding system and juggle their own life and family matters at once. So if you are appointed a deputy on behalf of a family member, it is a considerable responsibility, and you need to manage your expectations, and it will take up, a significant amount of your working week. So in order to help people navigate their way through this maze, specialist independent financial advice at this very fragile time, we can help you reduce the stress involved, and also we can make a huge difference to the overall planning, whether it's a success or not. But that's the theory. Let's just take a step back and, what is later life financial planning in real life? So we're going to take the example of Mary here. And I suppose this is accentuated because throughout the last year or so, we haven't really been able to see our family members in the same normal way as we have done in the past. So in this particular scenario, Mary, she had a dementia diagnosis. It's been on its progression in the last year or so. And now she needs much more supervision, day and night. In the past and up till now, she's managed to cope okay on her own. She was widowed 10 years ago. And her son and daughter, they both live and work elsewhere in the country these days. However, all of a sudden, Mary's becoming injured after suffering a fall in the street. Luckily, it was in a public place, and someone did manage to call the ambulance in time, and she's now in A&E. But because she's relatively old and frail, she's not going to recover in a hurry. As part of the discharge process, Mary's needs were assessed, and it's been strongly recommended as part of her plan that she cannot return home unsupervised, otherwise she may risk doing harm to herself. Mary now needs to move into a dementia specialist care home in the next 3 weeks, because that's when they think that she's going to be ready to be discharged from the hospital. And the estimated cost is £48,000 a year. Yes, that's £4,000 a month. And even in the Southwest, that's not entirely, that's not a made up figure. That's the type of cost that people do need to take into account. Mary, in this scenario, did manage to put in place a lasting power of attorney a few years ago while she was able to, and her son and daughter are now responsible for her property and financial affairs. As I said, they do, however, both work full-time and they do have young children of their own. So what did Mary do very much to her credit many years ago? Well, the first thing is that she arranged her lasting power of attorney with a regulated law firm, and it was registered with the Office of the Public Guardian at outset. The Office of the Public Guardian is the administrative arm of the Court of Protection, and they deal with lasting power of attorney matters, registration and the like. So by doing a lasting power of attorney, she was able to appoint her children to act for her at a time when she was at her most vulnerable stage in life. She trusts her children more than anyone in the world to look after her. And hopefully we can assume that her children were happy to take on that responsibility as well. So Mary's children can now manage her finances for her and act in her best interests. So the first thing they would have done or should have done is that they would have registered the power of attorney with the bank first and foremost, her current accounts, and then for other assets such as investments, and also, most importantly, her utility providers. If there's a problem with her electricity bill and she gets cut off and nobody's got authority to talk to the energy provider, then that's a problem. But by placing the power of attorney with each of these providers, and it's important to do a long list, go through somebody's current account and look at all the direct debits that are going out each month. It's important to engage with all of those providers. So when the time comes, the trusted or appointed people can act and solve problems as they arise. So as I said, the children can now take these decisions, and also including health and welfare decisions, if this option was selected in the lasting power of attorney. So first and foremost, it's ever so important, no matter what stage you are in life, it's never too early to have a lasting power of attorney. You never know when you might need to call upon it, and it could happen to you too. I do hear many objections over the years in terms of it will never happen to me. Well, it probably will. So I would suggest you get a lasting power of attorney in place. So this immediately brings up a number of questions, because Mary has gone from a situation where she was just quietly just getting on with life okay, but now she's in a crisis position. So the questions that come up: so how is Mum or Mary going to be able to pay for her care? Can she turn to the state for help? Can she turn to the local authority? Will she have to be a self-funder, i.e. pay for it all herself? Will she have to sell her house? What if she can't be cared for at home, and it's been recommended in Mary's care plan that she goes into a specialist dementia care home? Will she eventually run out of money? And how quickly before we need to change plans again? So for example, if she spent all her money, her own money, paying for private care, and she ran out of money, would she then need to turn to the local authority, and would they move her? And is that going to have a damaging effect on her state of health, for example? The move of the change in care homes. This is later life financial planning. These are the types of questions that we help our clients answer, and this is the reassurance that we give our clients with the good plans that we put in place, the good strategies that we help our clients with. So I've spoken about attorneys and the importance of having a lasting power of attorney document in place. So we're going to cover that briefly. So all about attorneys. It's your choice. You can choose your own attorneys to act on your behalf whilst you have capacity. So for example, if you want to nominate your son and daughter to take joint decisions on your behalf, you can, and that's called a joint and several appointment. Also, you may not know this, but perhaps if you struggle to think of somebody who's going to look after you as an attorney, you can appoint your solicitor or a regulated law firm. All law firms will act as an attorney for private individuals. Yes, you do have to pay for it, but you have an impartial professional person looking after your best interests at all times. The lasting power of attorney, the paperwork is done, and then it's registered with the Office of the Public Guardian. It comes into force when the donor or the person who did the power of attorney loses the capacity to manage their own affairs. So it could lay dormant for 20 years. But the important thing is that it is registered at outset with the OPG, the Office of the Public Guardian, and can come into force relatively quickly. There are two different types of attorney for different types of decisions. There is one for someone's property and financial affairs, i.e. running their finances, their bank accounts, maybe even being able to sell their property, and one for decisions about their personal welfare. So this could be health treatments, preferences, for example, consent for vaccinations, for example. Attorney has to be somebody over 18, a trusted friend, relative, and can't be a bankrupt. And as I said, it could be a professional such as a lawyer or accountant. I suppose really if you're considering who to appoint as your attorney, one thing you may wish that family members who love you, who want to do everything to act on your behalf. But perhaps if they live elsewhere in the country, perhaps if they live in another country, is this going to be practical? And also, I suppose, in a kind of mercenary way, do you want them to be thinking about looking after your best interests, or do you want them to be thinking about their future potential inheritance? Remember, all of this is designed at safeguarding you when you're at your most vulnerable stage in life. So have a frank think about this. If you can't think of anyone appropriate within your immediate vicinity, a professional attorney could come in the form of a trusted lawyer or accountant. It's also good to note that before lasting powers of attorney, there was something called an enduring power of attorney. If one was set up before October 2007, it's still valid and it can still become registered with the OPG when the donor starts to lose their capacity. An example in point, a family member of mine did their enduring power of attorney back in 2006, and just before Christmas, it got to the stage that we had to register the enduring power of attorney with the OPG. Excuse me. The registration process was actually relatively quick. I understand that, with coronavirus delays, that registering powers of attorney has come under some pressure at the OPG, but I was quite pleased to see in my January post confirmation that the enduring power of attorney had been registered. Since that time, I've gone and done what exactly I said in the previous slide. We registered it with the current accounts. We're going through the utility providers and also some of the other bank accounts and things like that. So there is a checklist to be done, and we're doing it at the moment. So the enduring power of attorney is still valid. Importantly, the enduring power of attorney is really for property and financial affairs, not necessarily health decisions. If there was ever a need to change attorneys and things like that, it's less flexible compared to the modern lasting power of attorney. Now, attorney is something that you can do, as I said, whilst you have your own capacity. You have the autonomy to choose who you want as your attorneys. If you don't choose attorneys and you lose your mental capacity, we're going to move on to deputies. Now, deputies is a deputy is a person appointed by the Court of Protection to manage the affairs of someone who lacks the mental capacity to manage their own affairs. Now, this could be a relative or a friend of the person who lacks capacity. And again, once again, it could be a panel deputy, that's a solicitor or a law firm appointed by the Court of Protection on behalf of others. But of course, somebody else is deciding who's going to make the most important decisions of your life going forward. Somebody with the power to close bank accounts, move your money around, sell your property with permission as well. So having an attorney really does get over the need to be having, to have a deputy imposed upon you, you could say. Whilst the deputy needs to act in your best interest, you do not choose who your deputy is. An example that I've recently dealt with, a daughter was asked to be a deputy on behalf of her mother who'd gone into a care home. They hadn't actually spoken for 20 years. So all of a sudden, the daughter was thrust into this situation where she was given the job of the deputy to look after the financial affairs of her elderly mother, and their relationship was rocky at best. Yeah, and it wasn't a responsibility that, you know, she felt duty bound to do this, but it wasn't a responsibility she felt she could delegate to anyone else. So she runs her life, and she also has a full-time job running her mother's affairs as well. There are additional reporting requirements as a deputy as well, such as the need to submit an annual report to the Office of the Public Guardian. It's a comprehensive breakdown of all income and expenditure over the years, and any actions or decisions made as well. So it's an onerous task, and it can be quite intimidating for the layperson. A deputy may also have to pay for a deputy bond as an insurance to safeguard against any financial losses suffered by any deputy failures. A deputy failure could be something, for example, such as placing money into an unregulated investment, for example, and losing money without any redress. A deputy bond could cover those types of decisions. So that's deputies and attorney planning. And Patrick, I believe you've got some questions that have come in.
Yes, yeah, thanks, Simon. I think you've answered one already. The question is, are enduring powers of attorney created before 2007 still okay to use? I think you answered that in the affirmative, didn't you? That
yeah, very much so. I mean, what I'd say about enduring power of attorneys is that if it was created before 2007, we're in 2021 now. That's quite some years since the original event. Like anyone would review their will and perhaps not consider about who you're going to leave your money to, but actually choice of executors. It's good to check who you actually appointed as your attorneys before 2007, because if you're not happy with the choice of attorney, an enduring power of attorney doesn't make it necessarily easy to change. You would have to upgrade to a lasting power of attorney. So it's, if you have done the right thing before 2007, it's good to review these things. Also, if you've developed or you have any specific medical treatment preferences that's not necessarily covered by the scope of the enduring power of attorney, so it may be well advised to consider doing an upgrade to the enduring power of attorney into a lasting power of attorney.
Okay, thank you. Another question. You mentioned the reports that deputies need to make to the OPG annually, and it includes like an income and expenditure account and actions taken. But is there a kind of format that needs to be in? Because like this lady, the daughter you were saying, you know, you could be thrust into the situation where you're not kind of financially savvy particularly, you know, but you're having to do this job. Is there kind of a template, or is what's the advice there on what you know specifically need to put into that report?
Yeah, so the OPG will write to the deputy and say your deputy report is due in X number of days, and you have to get it sent to us by this date. Otherwise, there'll be questions to answer. So it can be quite an intimidating experience for a layperson deputy to complete the report. It can be completed online, or there is a paper version. And yeah, it's a long form really. You need to put in opening balances of everybody's accounts, or you know, the person's accounts at the beginning of the year, closing balances at the end of the year, and then you have to give a comprehensive breakdown of every piece of expenditure, itemized, throughout the entire year. The thing about making decisions on people's behalves as well. So, for example, if you've sold investments or bought investments, you have to put in what you've done and why. So somebody reviewing it at the OPG could actually come back and say, well, why on earth have you done this? Has it been in the person's best interests? So it is open to a lot of potential scrutiny. So it's quite a task for the layperson, I would say. But you know, I do help some lay deputies with this type of work, or indeed, it's a lot easier if people had appointed a professional attorney in some ways.
Yeah, and so, I mean, if this lady had refused to act for her mother as a deputy, you've just said, look, I'm not doing it, I'm not qualified, it's just too much. and then they would ask somebody else, presumably, would they? Or?
Yeah, it's likely they would have turned to somebody called a panel deputy, which is there's a number of solicitors in the local region are on a list of preferred providers, you could say, with the courts. But in this instance, they turned to the family, but they probably didn't know that they hadn't spoken for a while.
Okay. A couple of questions we've received actually sort of live, and there are a couple we received, one from Janet and one from an anonymous person I'll get to, so I haven't forgotten you. But one from, a good one from Andrew, I think here, Simon, is he asks, can you outline what the assessment is for deciding capacity? And does this differ on the type of LPA applied for? I guess that's between the kind of health LPAs, isn't it, and the finances, is that right? Or
yeah, I mean, when it comes to, assessing capacity, first port of call is probably the local GP. Following on from there, it could be a professional capacity assessor who looks at not only verbal communication, but also, in the way that, verbal communication is only a small proportion of somebody's ability to communicate. If somebody is becoming generally a little frail, you could say, and perhaps it's time to start taking over or looking after their financial decisions, then it's time to put in place the power of attorney. Okay.
And then one final question at the moment, then actually, one of your colleagues, good afternoon, Simon, Simon Valentine Marsh, that is, can the attorneys delegate the management of the individual's investments to a professional? I suppose they'd be discharging their duty because they could say to the court or whatever, look, I discharge my duty by getting a professional to manage the investments. Would that be right?
Yeah, so if an attorney or professional decision maker does not have the appropriate accreditation skills and training in that particular area, so this could be, financial planning, this could be property investment advice, anything really, then they're strongly advised or duty bound, you could say, to seek professional advice. We manage a lot of investments on behalf of attorneys, on behalf of their clients. A lasting power of attorney document may indeed have specific provisions as to restrictions and things like that. But if not, then an attorney or a deputy can employ somebody to manage investments on their behalf.
Okay, actually, yeah, thanks, Simon. We have just had one further question I think we can deal with now before we move on, because it is relevant. The question is, can we go further into the deputy bond? So I'm guessing, what does that bond look like, and how is it assessed, that kind of thing?
I think the deputy bond would largely depend on the individual's key responsibilities, really. And being a bond, it's an insurance product, so the premiums or the amount of money that one would go in is likely to reflect the risk of the situation. But if somebody wants to send in an email to us, then we can deal with that question at the end, or we can deal with it after
specific circumstances. Yeah. Okay, lovely. Right. Okay. If we can carry on with the next sections from you, then, please.
Yeah. Thank you, Patrick. So we're going to be talking about state funding and benefits. So if somebody is particularly vulnerable, will the state help in any way? Just trying to click on the right. Here we are. So first and foremost, the NHS is there to provide us with healthcare. And if you're vulnerable, suffer from dementia, or in a care home, and you need NHS medical treatment, the NHS continues to be there. However, somebody needing care in England and Wales, they have a complex medical problem, or indeed a disability which is deemed to be a medical problem, they may qualify for something called Free NHS Continuing Healthcare, or CHC. If somebody does qualify for NHS CHC, then the NHS should meet the full cost of the care, including the care provided at home, in a nursing home, or in a hospice. It's not means tested and no personal contributions are needed. So, as I said on the slide, does this mean care fee funding problems are instantly solved? And the answer is unfortunately not. If the NHS had to provide healthcare for everybody in a care home, the cost to the taxpayer would just be off the charts, you could say. So it's really reserved for those who need it most or perhaps have a terminal condition. The assessment is very strict, and it's well above the type of care, social care services a local authority could provide. The Alzheimer's Society, for example, has campaigned long and hard for the scope of NHS CHC to be extended to people with dementia sufferers, which is a very common condition for people in a care home. At the moment, dementia is to be regarded as a social care issue rather than a medical one, despite the fact that it is a brain disease. So there is an inequality there, but it has to be measured up against the public purse's expenses. So, and as part of somebody's assessment process, it will be considered, or attorneys or individuals need to push for it to see if they can be considered for NHS continuing healthcare. They could also get a lawyer involved to fight their case for them in more complex situations. But it's something that, possibly to ask for, but manage your expectations. It won't be granted to everybody. Somebody I dealt with a few years ago before he died was in receipt of NHS continuing healthcare. Despite him having a terminal condition, he was told that it was constantly under review. So even to his dying day, he was left with the stress that his CHC funding could be taken away from him at any moment. And he was worried about having, the funds to pay for his own care. So yeah, it's something to ask for, but manage expectations, I would say. So here's an easy win for a lot of people. If somebody's unable to qualify for NHS continuing healthcare or CHC, an easy win is to apply for something called attendance allowance. Attorneys and deputies can apply for the person they look after. And it's a non-means tested tax-free benefit. It's very much underclaimed. I think it's because, from personal experience, it's got a funny name in today's world. It doesn't really make too much relevance to what, how the money's being paid out. It's almost the equivalent of disability living allowance, or PIP, you could say, personal independence payments in retirement, but they continue to call it attendance allowance. It's not a great deal each year, but it can certainly help. And as it's non-means tested and tax-free, it's something worth considering. And it's paid at two rates. So the lower rate in the current tax year, £59.70 a week, which is just over £3,100 a year. If somebody qualifies for this, they'll need frequent help or constant supervision during the day or at night. They may be able to apply for the higher rates if their needs are higher, which is £89.15 a week, or just £4,600 plus a year. And that's help day and night, not day or night, as it were. And it's also possible, if somebody's on the lower rates and their condition falters, they can ask for an upgrade and go on to the higher rates. And again, anyone over state pension age can apply for this for free. And it's again, it's a long form, and people need to be candid with their medical matters, include their prescriptions. And as I said, the more you put on there, the greater the chance they have of making the correct decision for you. And there are, things such as continence, whether you've had a fall, all types of things on the form. So I usually encourage people, if they are going to go down this route, not to be too proud and hold anything back. They have to put everything they know on the form, because that will maximize their chance of being awarded the attendance allowance. And in some ways, the attendance allowance, like I said, they're not huge amounts, but if somebody is on the lower rate, for example, you just need to bring that back in terms of what that 3,100 would pay for each year. It might pay for a month in a care home, so you've only got 11 months out of 12 to pay for, or it might pay for other things. You can use the money for whatever you want. So I've just covered briefly on state funding. There is a variance to NHS provision as well called nursing care. But I think to keep today's presentation suitably brief and not go into all of them, we'll just cover those two for today. We're going to move on to local authority funding, which is more social care. So will the local authority help? Under something called the Care Act 2014, local authorities have a legal duty to meet an adult's eligible care needs subject to their financial circumstances. That's quite important there, really. Means tested care. So in order to do this, they must conduct a needs assessment to establish their eligible needs, complete a financial assessment, i.e. the means test to find out what level of support the local authority will provide, and then provide information and advice on how these needs are met. And it's more commonly known as a care needs assessment. So going back to our scenario, Mary in hospital, awaiting her discharge, she would have gone through a care needs assessment at that point to determine really what her outcome is going to be after her hospital discharge. And in this particular instance, in the example, it was recommended that she wasn't able to live alone, look after herself anymore, that she had to go into a dementia-friendly or dementia specialist care home. The important thing with all of this is that although local authority help care paid for by the public purse is means tested, the means test is to determine the level of local authority contribution, i.e. how much they will pay on top of yourself. But they must still help people and those responsible for them make decisions about how they want their needs to be met and prepare a care and support plan, irrespective of whether or not financial support is being provided. So if your means are such that you would never need to call upon the local authority for any help, they still have to provide you with the care plan, regardless of your means. So for those who do wish to call upon the local authority for their social care, there is a capital threshold. And your assessable capital, and it has this figure hasn't changed in quite some years, but it needs to be below 23,250. This could mean the cash in the bank, any shares or investments that you own, any property assets, and shares could also mean shares in a business, in a family company as well. And if you would live alone, it could also mean your family home. We're going to go through some disregards for those who live together, husband and wife, for example, a bit later. But in reality, if you own capital over 23,250, this all has to be sold down and used up first down to this threshold before you may qualify for means tested financial assistance. So the bar is set extremely high once again with the means testing. Income sources are also taken into account as well as your capital. So this could include the state pension, any final salary pensions or pension annuities that would need to be paid to the local authority for the social care funding, or at least contribute towards it. If we've got a husband and wife scenario and it's one of the spouses needs the help, allowances can obviously be made if somebody shares their household expenses with a partner, spouse, or other financial dependent, if they're not staying at home and not needing care. So for example, if Mary's husband was still with us in the scenario and Mary's husband didn't need any help and Mary did, if they were relying on two state pensions and perhaps Mary's husband's pension, all of the income wouldn't need to go towards the local authority to help pay for the care. It would be proportioned so that Mary's husband, if he was alive, wouldn't necessarily suffer an extremely impoverished standard of living because all the income is going in the direction of the local authority. And those decisions are often challenged, and they're often challenged in court as well. Income can also mean income from savings, investments, land and property profits, i.e. rental income. Quick points, what we do see more and more is that people are moving into retirement and perhaps they're not touching their pensions until very later on in life. So when I say pensions, that means things such as personal pensions, SIPs, SASs, those types of things. If somebody hasn't touched their pension and perhaps just wants to leave these funds to as an inheritance for the next generation, which is possible if it's in the right structure, the notional income value is taken into account, not necessarily the capital accounts. So, for example, if someone had £300,000 in a personal pension account, the capital account of 300,000 wouldn't be considered. It would be the equivalent income if you converted the pension into an annuity. So if that was a 4% annuity rate or something like that, that would be an equivalent notional income rate of maybe around 12,000 a year. With the new pension freedom legislations, people can be a lot more flexible with what they do with their pensions in retirement. But in this particular instance, you wouldn't be forced to cash a whole £300,000 pension fund as one lump sum because of the tax implications. First and foremost, you would probably lose half of it in an additional rate income tax, but it's treated on the notional amounts. This is quite relevant in the way that the family home, it can be disregarded. And this is particularly important because it may only be one person who needs the care. The other spouse or civil partner may just stay at home. So the family home may be disregarded from the local authority means test in a number of scenarios. There is something called the 12-week disregard when somebody first moves into a care home as a permanent resident. It might take that long to sell the house, for example. The care may be provided for the individual on a temporary basis. So someone might be in a care home on a respite basis, for example. Not so common, but if the individual continues to live in the property and receives care from the local authority at home, don't come across that one very often. But more importantly, as I said, if the individual's spouse or certain other relatives continue to reside in the property, even if they're on the title deeds or not, the family home may be disregarded. And that might be a non-married family member over the age of 60, for example, or a dependent, you could say. So we're going to move on to deliberate deprivation. What I've covered since then has really been what you may be able to ask the state or local authority for to help. But in reality, for most care fee funding, it's going to fall on the individual or the individual's family to help with care funding. And I'm just going to roll my blind down because I'm being obscured by the sun. There we are. I can see again now. And it's quite a big thing, deliberate deprivation. So it begs the question, if you've got to face capital thresholds of the local authority to fund some of your care, and if you can only apply for, say, attendance allowance from the state and with no other support from the NHS, for example, why don't I give away or just enough of all my money so I can get the local authority to pay for my care fees? Yeah, why not? Why not? Why don't I divest myself of all my assets and then the state can pay for all my care funding? Well, that's something called deliberate deprivation. And this is Age UK's quote, which I've borrowed and credited. If somebody intentionally reduces their assets, such as money, property, or income, so they won't be included in the financial assessment for care home fees. This is known as a deprivation of assets. If your local authority or council concludes that you have deliberately reduced your assets to avoid paying care home fees, they may still calculate your fees as if you still owned the assets. So if it has been successfully proved that you've taken part in deliberate deprivation of assets and income, you will still have to pay the same amount. Giving away all that money perhaps wasn't the best idea in the first place. So here are some examples. Gifting away your home to your children whilst you're still living there. Now, from an inheritance tax point of view, that would be something called a gift with reservation anyway, or a sham gift, because you're not giving away the beneficial ownership of that asset away. You're just giving away the titles, as it were. If you still lived there and didn't pay your children rent, for example, that could be a deliberate deprivation and wouldn't work for an inheritance tax strategy either. You could gift money or assets to put in someone else's name. So you could put the money you could give the money to a friend or another family member, for example. You could sell assets to friends and family at significant discounts. Below market value is another term of describing it. You can rely on or try and rely on certain trust measures, which you might have seen in an advert in the local newspaper, to avoid care home fees while still enjoying beneficial ownership of your own home. You could deliberately not claim a lottery or premium bond win. Why would anyone do that? Or even an inheritance. And also, if you're going through a divorce process and you may or may not be coming into certain assets, by not completing the divorce process could be another example of deliberate deprivation. With all deliberate deprivation cases, the local authority, cash-strapped as they always say they are, obviously, they're stewards of the public purse, so everybody must be treated fairly. And if somebody does have means, then it is fair enough that they should put some contribution towards the system if they're going to receive care when they're most vulnerable. But what was the local authorities looked at it like this? Was the primary motivation with any of these deliberate deprivation methods to simply avoid paying care fees? The burden of proof is almost on the individual to say that you're innocent, and defrauding or making sure that you were giving away assets to avoid paying care fees is something that you have to prove. So going back to some of these really. So what was the primary motivation? Gifting money or assets to put in somebody else's name. Well, if somebody did it, perhaps, in my age, early 40s, gifting money or assets to put in somebody else's name, well, deliberate deprivation for local authority care fees probably wouldn't be a primary motivation. Just, altruism because I'm nice. But this is a fictitious example, not on real events. So it wouldn't necessarily be deliberate deprivation. But if you take, for example, Mary in our scenario, if she's in her early 80s and she's, if she's, medically frail or, vulnerable, care is more likely to be on her radar than it is for mine. So that could be considered a deliberate deprivation if it can be proved that that was her motivation for doing so. Just another one, for example, giving away your home to your children. I couldn't do that. My children are too young. But again, the primary motivation, are they trying to avoid it so the children inherit the house rather than the money going or being used for as a source of capital for care fees? So they're looking at this, really what your primary motivation was. Feel reassured. Every local authority has probably seen every excuse in the book. And they've got extremely wide investigative powers. They can go back as many years as necessary, almost like the insolvency laws. It's not necessarily 7 years or 14 years for inheritance tax planning. They can go back as many years as necessary. They can ask for bank records, and they can look for suspicious things such as going to the cash machine at 3 in.the morning and making multiple withdrawals of cash to give to family members, because it's all on the electronic record these days. So I think if somebody is in that position, and particularly if somebody's served by a family member attorney, what is the primary motivation here? Is it for the attorney to protect their inheritance, or is it to avoid paying care fees? So care needs to be taken in this area, and if you are relying on the local authority for help, you may not be able to get away with it. So Patrick, you've signaled me. You've got might have some other questions now. So we'll just before we go on to the last stretch. Okay.
Yes. Thanks, Simon. A simple one, really. Actually, attendance allowance. I know clues in the name, but very good question, really. To claim attendance allowance, do you actually have to have somebody attending to you in your home? Somebody else coming to your home to claim it?
Yeah, that's a good question. It's really based on your individual needs. So going back to what I said, if you need help with really just existence, you could say, day or night, or day and night. It may involve a carer coming into your own home, for example, or you may live alone, but you can spend the money on whatever you like. They don't check up on what you've been spending the money on.
Yeah, so it could be a family member going in rather than a sort of paid carer or something like that, couldn't it?
Yeah, I mean, unpaid carers are the, I suppose, in some ways they're the backbone of, a side of society that doesn't really get talked about enough, really.
Yeah.
And the number of unpaid carers, i.e. family members doing the right thing, is off the scale, really, but they just fall between the cracks. It is possible for some family members to claim something called carers allowance, but it's another means tested benefit, and it's quite strict, and you have to be on pretty modest means before you can claim the carers allowance, and also the number of hours that you work during the week as well.
Yeah, and I think you can't claim carers allowance and attendance allowance together, I think. Is that right?
Well, the individual receives the attendance allowance, and the
Yeah.
carer would make their own claim for carers
Right,
allowance on their own circumstances.
Yeah, I know when my mother went into the home, the attendance allowance obviously stopped, but she did get something called funding nursing care, which worked out about £200 a week, I think.
Yeah, so what that is, I mean, I didn't really want to go into too many variants of the NHS measures, but
No.
Essentially, really, once the NHS starts paying for or contributing towards the cost of care, then the link with attendance allowance comes to an end, really, because then it's funding sources from two sources of government, you could say. If somebody goes into a private care home and pays for all their care fees, the attendance allowance can still continue. But if they are able to apply for NHS funding, either CHC or registered nursing care funding, then the attendance allowance would tend to come to an end.
Okay, thanks. Right, we'll get to the question from Janet, asked almost at the start of the call. Her mother going into a nursing home, but the mother was a partner in a farming partnership. So there's the farmhouse and other sort of assets, as you said earlier. You seem to alluded to the fact that business assets would be taken as part of the assessment for the 23,250 limit. So would she be theoretically forced to sell her, or they sell the farmhouse so she can realise her share? Or how would that work, do you think?
Yeah, it would largely depend on really what the family's assets are, what access they have to liquid assets, i.e. cash or investments or something like that. It could also be possible if one person needs the care and it needs to be paid for and others remain in the house. It could also be possible to raise money against the value of the property, for example, maybe using something called an equity release or lifetime mortgage arrangement. So it would really be a bespoke situation to the family in terms of using what assets are available first. But if somebody is in business, then if there is an intrinsic value to their business, and then that would be considered in the means testing for income as well as capital. So the income would be the net profit share from the farming business, for example.
Okay. Another question, is this 23,250, is that a common amount across all local authorities, or is it just for the Southwest, or is it national?
Yeah, it's across the board. And so I suppose in certain areas of the country that it might be a bigger figure for some than others, but it's not an arbitrary figure, and it's the same across local authorities. They don't really have any discretion to raise or lower that, and it hasn't changed for some years, really. Okay.
One final question at this stage, then we can get to your last segment. Obviously, about when you were saying about sort of deliberate deprivation of assets, and it's on obviously the person rather than the authority to sort of prove that they haven't sort of deprived their estate of assets. But the question is, if you made a gift to a family member many years ago, I mean, how far back do they go? Is there a rule of thumb, or does it just depend?
Well, I suppose it really goes back to the idea of what the primary motivation for doing so really was. If somebody attended a seminar where everybody bought into, some of these avoid care fees trusts or something like that, well, the name's on the title really. If somebody went to that seminar, then the primary motivation might have been to consider avoiding care fees really. In terms of giving gifts away, if somebody, I suppose, it depends on whether they were served by a power of attorney, for example, whether the individual had the capacity to make the gift at the time. If it could be, for example, grandparents helping grandchildren get onto the property ladder, as long as it's all very documented. And for example, if grandchildren helped and were given a gift by their grandparents to get onto the property ladder, as a result of that gift being made, did the grandparents suffer a complete decline in their standard of living, for example, or cause them hardship? So if they could more than afford to give that gift away, then the primary motivation is to help them and not necessarily give away money to avoid paying care fees. Also, to bear in mind with deliberate deprivation is that if you have money, it's probably best to ensure that you have received the best care possible to maintain your dignity later on in life. Whilst the local authority does its best with its limited means, the care homes that one may need to move into is at the choice of the local authority, not yours. So if you don't like it, effectively, if the local authority decides, if you've got rid of all of your money, then you and the family has lost autonomy because you're at the behest of the local authority who choose where you will go, and it might not be in the best part of town.
No, it's a very good point. I'm just conscious of time, Simon, so can we, when we have got a couple of questions that we might have to answer or you can answer afterwards outside of the webinar. So if I can pass back to you for your final segment.
Yeah, thank you. Okay, so we're going to be talking about paying for care. So this is a few ideas that we put in place for a number of our clients. I think really paying for care, it is a bespoke exercise, really down to the individual circumstances. And this is really where we come in, where we look at all the options available to a family or to a professional attorney or deputy to determine the best way of getting from A to B. One thing that is often overlooked, but it is possible to consider, is something called the Local Authority Deferred Payments Agreements. It is only available to certain people in terms of, again, it's means tested. Some people may not wish to sell the property to pay for their care fees immediately. So it's the Local Authority Deferred Payments Agreements is almost the local authority putting a charge on someone's property, and it's paid off when the individual dies, when the property is put on the market and the local authority get their money. It's available to those who have been assessed by a local authority to require a care home permanent residency. The individuals have to have less than 23,250 in assets, excluding the value of their home, and if the home is not disregarded for the purpose of the means test. So there is something available from the local authority where effectively you defer your payments until later on down the line. But as I said, really, later life financial planning, we're looking at the whole picture. We're doing a detailed analysis of someone's income, present and anticipated expenditures as well. We look at the way that pension income, for example, may index in line with inflation measures over time. And we also look at the fact that care fees costs will probably rise at a higher rate than inflation over time. So we do model these things over the long term. And then really, once we've done that data crunching exercise, we'll be looking at the entire market to research a number of solutions, and we'll form recommendations to give people a detailed, bespoke plan and also a costed plan on how to maximize their assets and, most importantly, help ensure the money does last as long as possible. The problem with doing nothing is that if somebody, for example, sells their house and goes into a care home and nothing is done, there's every chance the money may just sit in the bank doing nothing for years. The Bank of England base rate is at 0.1% at the moment. National savings income bonds, which we would consider almost the default option for large cash balances until very recently, now pay 0.01. So effectively, you're paying national savings to hold the money for you. Cash deposits alone may not work in today's low interest environment. Remember, with care fees and ongoing expenses, you need to take into account the fact that inflation will make these costs rise over time. And if your cash is not growing at a rate that exceeds inflation, it's going backwards. And the cost of care, as I said, it's more likely to increase at a higher rate compared to headline inflation, for example, RPI, Retail Prices Index, or CPI. CPI inflation measure is composed of a number of things, and not all of it's relevant to the retired or later life generation, you could say. CPI, for example, can include things such as the cost of video games and things like that, where more things such as heating and food, utilities are more important. So inflation is flexible and relevant, and or subjective to the individual, you could say. The cost of running out of money by just staying in cash is very high. And this is an example. So really, if you had £250,000 and you were making monthly withdrawals of £4,000 a month to pay for your care fees, if it was just in cash, you wouldn't see any growth, and it would just be in permanent decline until the money ran out. Another example to use as a mix and match solution could be something called a care annuity. Now, care annuities are only available to those who go to a specialist accredited advisor, such as a member of SOLLA, of which I am a member. Not much is known about them in the public domain, but the idea is to provide index-linked guaranteed income for life. So individuals would put down a sum of capital, and the insurance company would give them a level of guarantee for the rest of their life. It's medically underwritten at outset, so it takes into account somebody's mortality and morbidity factors. So perhaps the more ill you are, as it were, the more income they would give you at outset. You do have to take into account, of course, somebody's life expectancies to reach a break-even point, and then a decision can be made about care annuities, but they can be paid tax-free to a care provider registered with the Care Quality Commission. And here's an example chart against this. So that in purple, what we've got here is somebody paying for their care fees just from cash in the bank, and you just see just a guaranteed decline. Whereas if somebody had put a similar amount into, say, a care annuity, and that care annuity indexes by, say, 8% a year, this individual would have to live a certain amount of years, of course, before they reach their break-even point, as it were. But it does provide, or would provide, the attorneys or deputies or the individual the reassurance that they would have a guaranteed level of income going up over time. And if it's done correctly with the numbers to meet the cost of the care, for example. But it does away with the idea that if somebody did choose one of these ideas, they may not run out of money during their lifetime. The risk, of course, is if they die earlier, and going back to this idea of the break-even points. But you can incorporate things such as life insurance benefits in there. So, for example, the family would be compensated if somebody died earlier than planned. But these can be very useful ways of generating high levels of guaranteed income without any investment risk. Talking about investments, yes, it is possible for attorneys to invest on behalf of the person they're looking after, or the individual if they still have capacity. And we look after a number of investment portfolios for our clients to go towards care fee funding, made perhaps in conjunction with the care annuity and access to cash deposits. So we can invest into portfolios to produce regular amounts of income, and we can, and also the capital is positioned for long-term growth as well. The important thing in this instance is funds do remain relatively accessible and adaptable for any future changing needs. So, for example, if a large amount of capital did need to be realised, by making use of annual ISA allowances and things like that, for example, it would be possible to access sums without any big tax or adverse tax considerations. We can convert growth investments into income-producing ones, for example. So if somebody does have savings and investments, and they have been traditionally engineered for growth, we can help convert them into income-producing assets to provide an income stream to pay for care fees. And once again, the funds remain accessible and adaptable for any future changing needs. If somebody has deferred pensions or somebody has built up funds in pensions, we can advise on that to provide a regular income to once again suit your planning or income shortfall needs, or convert the fund into a medically underwritten annuity, for example, where indeed with some health questions, a high level of income can be produced for the individual that's bespoke to them. We can also advise on something called equity release. Now, this could be particularly relevant if one ill spouse needs care and needs to pay for it, whilst the other spouse stays at home, is well, and wants to remain in the family home. This can help generate tax-free capital from the value of the property. And it's also possible if somebody has buy-to-let properties, for example, you can raise a mortgage against the buy-to-let properties on an equity release basis. Therefore, there's no income test or assessment for investment properties. And rather than selling an investment property where you may be subject to capital gains tax, it would be possible to generate a lifetime mortgage against an investment property to generate a tax-free sum of income, or tax-free capital sum. These include drawdown facilities where you only pay interest on the actual amount of money borrowed, so you don't pay interest on the entire promised loan. If you only need £30,000 in the first year, for example, you would only pay interest on the first 30,000, and then you would draw down as you go. All equity release lenders are covered by the Equity Release Council, and they come with a no negative equity guarantee, so you will never owe more than the property value itself. And the money needs to be paid back either when somebody dies or if they go into permanent residential care. Finally, we have access to cash management platform tools to ensure that high cash balances are sensibly spread and do not exceed £85,000 per financial institution. When a house is sold, there is a grace period for the Financial Services Compensation Scheme measures to give you a certain amount of time to hold a very high cash balance, but that does subside over time. So by using a number of tools to actually make sure that you're getting the best rates of interest from the markets, we can help spread capital so that people, don't have more than 85,000 in a bank as well. So that's some examples of paying for care. As I said, it is a bespoke arrangement, and I just went through some headline ideas, but really that's the type of work that we get involved in. Those are examples of the types of things that we may consider in a scenario such as this to generate high levels of income for a family or an individual to make sure that their care is paid for and that their money lasts as long as possible. So it's just some concluding remarks really, and then I imagine we might have a couple of other questions. Unless your needs are very severe later on in life, you should manage your expectations of what state and the local authority may be able to help you with. There are, as I said, non-means tested benefits available to everyone depending on their needs, but chances are that you will have to pay for your own care. It's largely means tested. If you are a couple, what is your backup plan if one person receives all the pension income and dies first? That's a sensible question to consider. For example, if the husband has the lion's share of the pension income and it comes with a 50% widow's pension, is that going to be enough if the first person goes? People retiring now after 2015, it's previously the surviving spouse may have been able to rely on a lot of the state pension. Well, it's been designed now that people get more as the flat rate state pension, but indeed, the surviving spouse may not be able to inherit any of it or a very small portion of it. So that's something to bear in mind, really, for backup plan. And it is sensible to have a backup plan, and it starts with a power of attorney document put in place now, which is your ultimate insurance policy, you could say. If you do not have one in place, and you could by all means speak to your solicitor, or if you want to be directed to a trusted legal colleague that Thomas Westcott works with and trusts, we'd be happy to do that for you. If you are a family member or your client find themselves in a position where they need care and need to fund it privately, you should come to us sooner rather than later. in the scenarios I showed you where the person's cash run out over a very short period of time, don't come to us once the cash has been spent, because again, managing expectations, there may be a limit to how we can help you. But if you came to us early, then we could be a lot more creative and give you a great plan to give you the reassurance that you're doing the best thing for the vulnerable person that you're looking after. Remember, if you are an attorney or a deputy, your actions are answerable to the OPG. And there's been substantial case law over the years about attorneys making arguably the wrong decisions about the money that they were looking after. In today's world, there are a number of scams available on the internet about promising high levels of return with no risk and things like that. Always go to a regulated financial planning firm who will give you proper advice rather than internet promise advice. And finally, with all of this, whilst inheritance should not be considered the #1 priority, there is obviously a bias in the minds of family members who act as attorneys for vulnerable individual. But with correct planning in place to ensure that someone doesn't run out of money, by doing it properly and not leaving the money in the bank, for example, or going for any internet promised investment ideas, there is potential to leave an inheritance for loved ones, if indeed that was the will of the person that you're looking after, perhaps before they lost mental capacity. But once again, this is about looking after a vulnerable individual with their financial planning in their best interests, not necessarily the next generation first and foremost. And that's it.
Okay, thank you, Simon. Yes, if you can stop sharing, that's great. So, yeah, so I do apologise. We've run over the sort of standard hour. I think probably we could run probably 3 sessions on various strands of Simon's sort of talk today. Just a couple of questions then, and then I'll kind of wrap up. One from Debbie. Simon, she's saying, when would you start buying care annuities? Are they something you could start buying, before you actually sort of need them?
It's possible to plan in advance. There are deferred things out there which you can pay into, as it were, but there isn't currently an insurance market where you could pay regularly that would pay out in the event of suffering dementia. There are a few life insurance companies who do offer a token benefits, so as an add-on. So if you so there's one insurance provider which offers a dementia cover as a flat lump sum payout of say £10,000 if you were diagnosed. But currently the insurance market as it is quite reluctant to get involved in pre-funding care to the same measures as it was perhaps 20 years ago. Okay, thanks. One from Chris Preston here. He says, is he right in thinking there are some, in his quotes, clever investments which can be made but are excluded from the care home calculations because they have an element of life cover and that kind of thing? Yeah, that's a good point. So under the means tested assessment, certain investment products with a life assurance element can sometimes be excluded. However, what was the primary motivation for putting money into this investment in the first place? If the primary motivation was to avoid care fees, then it's not going to work. So for example, if somebody placed money into this style of investment, perhaps when they're in their 50s, and then needed help from the local authority when they're in their 70s, chances are that putting money into a life assurance bond was not the primary motivation. Avoiding care fees wasn't the primary motivation. So one needs to tread carefully with those, but sometimes they are disregarded from the means test. If somebody was receiving a regular withdrawal, i.e. income, perhaps that would not be excluded from the means test, but life assurance bonds, they do need to be treated carefully. Okay, thanks. One final question, actually. So I think one of my partner colleagues, Paul Stapleton, how easy is it to check, going back to what you were saying at the first part of the webinar, how easy is it to check that an LPA has been registered with the OPG? Is it just an online kind of thing, or is it? yeah, would have had documentation to confirm registration, and also you can phone them to double check as well. They're issued with reference numbers, so yeah, that's possible to do.
Okay, that's lovely. Right, I think we'll kind of wind it up there. I'm conscious of time. It is 3:15. We normally finish these things at on the hour, as it were. But as I say, it's been a fascinating glimpse into Simon's professional work and what he does, and he and the other guys. I would say that if obviously if we haven't got to your question, we have saved the Q&A so we can answer them. But if you put anonymous, I don't know if we can track that. So if you'd like to, if you don't think we've answered your question, just email us at events@thomaswestcott.co.uk, and then Simon and his colleagues can attend to these questions, obviously privately and anonymously. So just consider that. I'd just like to make you aware of another webinar we're running in 2 weeks' time on exit strategies for businesses. Which would then sort of almost tie in with what we've done today, really. My colleague Alison Watts, who heads up our corporate finance department, is doing that with one of my Plymouth partner colleagues, Ian Pring, and a commercial solicitor from Stephen Scone. Other solicitors are available, of course. So that's going to be a great webinar, 2 weeks' time, same time, 2 o'clock. So finally, I'd like to thank Simon for his efforts today. That was really informative, certainly resonated with me, my experiences with my parents, and hopefully you did as well. Thank you, our attendees, for coming along, and most of you actually can stay to the end. So thank you very much. Hope you got a lot out of it, and have a good rest of the week, and stay safe. So that's all for now, and see you on the next webinar. Bye for now.